Good morning, and thank you for joining me today as I present on the topic of Subchapter V of Chapter 11 of the Bankruptcy Code, dealing specifically with small business bankruptcy. First, a little about me. I've practiced in the area of bankruptcy law since 2004, when I started my career clerking in the United States Bankruptcy Court for the Southern District of New York. After completing my clerkship, I joined Arent Fox, a law firm with a strong creditors committee practice. I left Arent Fox to join Catton, where I worked on large syndicated loan restructurings, after which I joined Bloomberg's Law Group as a bankruptcy legal analyst. Ultimately, I missed practicing law, so in 2013 I started my own practice to give smaller individual and business debtors and creditors the same high-quality, personalized attention and expertise that is generally associated with big law. Now, a little about the state of bankruptcy. I'm often asked if bankruptcies increased significantly during the pandemic. You may be surprised to learn that they have not. In fact, bankruptcies are down more than 40% since 2019. Why is this? There are a lot of obvious factors if you consider the big picture. First, for the past few years, interest rates were at historic lows, so money was cheap. Additionally, while the COVID-19 pandemic created economic distress, aid packages such as the Paycheck Protection Program and economic injury disaster loans kept many small businesses afloat, but in many cases barely. Implementation of eviction and foreclosure moratoriums filled the gap for many businesses, albeit temporarily. Individuals saw aid through stimulus checks and increased unemployment benefits, in addition to the eviction and foreclosure moratoriums. And banks were issuing internal guidance in many cases to avoid calling loans that were in default special or non-performing assets. This is for the somewhat less obvious reason that banks have to maintain a certain percentage of performing loans to comply with their own regulatory obligations. At this point, most in the industry are anticipating an increase in filings, particularly for small businesses. Why is this? Well, for one thing, funding for aid packages is mostly depleted. The eviction and foreclosure moratoriums ended on January 15th of 2022. So, a lot of small businesses that haven't paid rent for 2 years are faced with having to come up with staggering amounts of back rent. While the economy is rebounding significantly in spite of recent world events, most small businesses lack sufficient cash to operate for more than 3 months if there's a problem. If you're a restaurant and your stove breaks, there goes 1 month. Landlords often haven't been paid rent for a long time and are not necessarily anxious to negotiate. And keep in mind that the foreclosure moratorium ended for them as well, so many of them can't. They now need money to pay their obligations or face foreclosure themselves. All of this is being exacerbated by supply chain shortages, causing an increase in the cost of goods, and labor shortages, increasing labor costs. Some small businesses are notoriously disproportionately impacted by these factors, as they generally lack economies of scale and large corporate structures to supply additional funds. Moreover, individuals who own small businesses are generally required to personally guarantee loans obtained through the Small Business Administration. Based on this, you can see where small businesses and their owners will likely need to seek relief in the coming months to restructure their financial obligations if they are going to continue. This leads to our topic today, small business bankruptcy, and how it may help some of your clients. The topics we will cover today include who can be a debtor, what are the goals of Subchapter V, what are the benefits of Subchapter V, which include the plan process and the absence of a creditors committee. What is the Consolidated Appropriations Act and what are its benefits? What are some disadvantages to Subchapter V? What is the role of the trustee in a Subchapter V bankruptcy case? And what are the specific duties of a Subchapter V trustee? Who can be a debtor under Subchapter V? An individual or a business can be a debtor under Subchapter V, but must opt in. The Small Business Reorganization Act does not repeal the existing small business reorganization provisions, but rather provides an alternative. As previously mentioned, the individual or business must have no more than $7.5 million in secured and unsecured debts. The $7.5 million debt cap is currently set to expire on March 27th of 2022, It may or may not be renewed, but most believe that it will be. A single asset real estate entity cannot opt into Subchapter V. A single asset real estate entity, or a SAR, is a single property or project that generates substantially all of the debtor's gross income as defined in the Bankruptcy Code. A SAR does not include family farmers or residential complexes with less than 4 units. The fact that only 50% of the debt is required to be from business activities has provided a huge benefit to small business owners who are commonly required to guarantee their business loans, almost always in the case of SBA loans, and who often do not qualify for Chapter 7 or 13. This is because filing under Subchapter V, in addition to, and in part because of its streamlined process, is considerably less expensive than a typical Chapter 11 bankruptcy case. So what are the goals of Subchapter V of Chapter 11? The first goal is to reduce the cost of entry for small businesses to reorganize in Chapter 11. Second, to provide better and more complete information to creditors. And finally, to provide an increased oversight both by the court and the Office of the United States Trustee. Because Subchapter V was enacted to streamline the bankruptcy process for small businesses and thereby reduce the cost, there are a number of differences in the process and administration between a standard Chapter 11 bankruptcy case and one that proceeds under Subchapter V. Because the provision is so streamlined, there's also a focus on providing creditors with better information. As we will discuss, Subchapter V offers small business debtors an expedited process, less paperwork, and the ability to avoid paying quarterly fees to the Office of the United States Trustee, making the process much less expensive. One of the key ways in which Subchapter V reduces the cost of a bankruptcy for small businesses is through the plan process. The plan must be filed within 90 days. The debtor must file the plan within 90 days after the petition date. The period may be extended if attributable to circumstances for which the debtor should not justly be held accountable. Second, only the debtor may file a plan. No competing plans are permitted. In a typical bankruptcy case, anyone, any party in interest, can file a plan after the debtor's period of exclusivity ends. In a Subchapter V, however, only the debtor may file a plan, taking some of the pressure off of the debtor. No disclosure statement is required unless the court, for cause, orders otherwise. Typically, a plan is preceded by a separate document similar to a securities prospectus that provides the information a typical creditor needs to decide whether to vote for or against the plan. The disclosure statement must be approved as containing, quote, adequate information to inform the hypothetical creditor's vote before the court allows voting on the plan. The disclosure statement is a detailed document and therefore costly to prepare. It also requires a separate approval hearing, sometimes more than one, adding yet another layer of cost to the Chapter 11 process. In Subchapter V, there is no automatic requirement for a separate disclosure statement. Instead, the plan itself includes a brief history of the business operation of the debtor, a liquidation analysis explaining what creditors would get if the debtor liquidated instead of reorganizing, and projections with respect to the ability of the debtor to make payments under the proposed plan. The court determines whether the plan itself provides adequate information. If a disclosure statement is required, the court determines whether the disclosure statement, which may be a standard form implemented by local rules, contains adequate information and may conditionally approve the disclosure statement subject to final approval at the confirmation hearing on the plan. Solicitation of acceptances and rejections may move forward based on a conditionally approved disclosure statement, and there may be a single combined hearing on adequacy of the disclosure statement and confirmation of the plan of reorganization. Additionally, Subchapter V provides for no absolute priority rule. The Bankruptcy Code provides generally for a waterfall of payments, whereby secured creditors are paid first from their collateral, then priority claims like certain taxes, then general unsecured claims, and finally, only if everyone else is paid in full, equity or the owners can receive what's left. If everyone above equity is not paid in full, equity generally can only retain their interest in the business if they contribute new value, usually a cash payment for creditors to buy their interest. This is called the absolute priority rule. Under Subchapter V, owners of a company that is not paying its creditors in full still may retain their interest in the business without contributing new value. This permits business owners a greater opportunity to retain ownership interest. Subchapter V also modifies the cram-down rules applicable in a typical Chapter 11 bankruptcy case. Typically, under a Chapter 11 bankruptcy case, if all impaired classes do not vote to accept the plan, the court can still confirm the plan so long as at least one impaired class votes to accept the plan and it does not discriminate unfairly against creditors and is deemed fair and equitable. Under Subchapter V, the requirement of a supporting impaired class is done away with, and the court can approve the plan over the objections of all creditors if it is deemed fair and equitable, which means that either all of the projected disposable income of the debtor within a 3-year period or a 5-year period will be paid to creditors under the plan, or there is a reasonable likelihood that the debtor will be able to make all of the projected payments under the plan, and the plan provides for appropriate remedies such as liquidation of non-exempt assets to protect creditors if payments aren't made. Disposable income for a business is defined as that income which is not necessary for the continuation, preservation, or operation of the business. Administrative expenses can actually be paid through the plan in Subchapter V. Normally, a debtor must pay all post-petition obligations, otherwise known as administrative expenses, in full on the effective date of the plan. The effective date of a plan is when the plan becomes effective, typically within 30 days after the court order approving the plan becomes final. 14 days if that period is waived, in which case it can become effective immediately. The SBRA permits those claims to be paid over time through the plan, providing the debtor additional time to come up with cash to cover such expenses. The plan can be modified after confirmation. Generally, once a plan is confirmed, it can only be modified in immaterial ways, the idea being that the plan as approved is what creditors agree to accept. Otherwise, a debtor is required to resolicit votes on the plan, which is time-consuming and therefore costly. Under Subchapter V, if circumstances warrant a modification after confirmation, after notice and a hearing, the court may permit modification of the plan. Instead of requiring the debtor to resolicit votes, the court will allow voters of claims in impaired classes to change their original vote within a period of time fixed by the court. Finally, disinterestedness of professionals is modified. In general, a professional retained by the estate must be disinterested. This means they can't have a stake in the outcome of the case. As such, they can't be creditors of the debtor. Under Subchapter V, the disinterestedness standard is modified to permit a professional retained by the debtor to have a claim of less than $10,000 against the debtor. This allows the debtor to enter bankruptcy without coming up with funds to pay all outstanding amounts to its professionals or to find new professionals. Another benefit of a Subchapter V bankruptcy for a debtor is the absence of a creditors committee. The purpose of an unsecured creditors committee is to look out for the interests of all unsecured creditors as a class. In a typical Chapter 11 case, there is a presumption that a creditors committee will be appointed by the Office of the United States Trustee. Subchapter V provides that no creditors committee will be appointed unless the court directs otherwise. There are advantages and disadvantages to this. In practice, often the U.S. trustee is unable to find creditors interested in participating on an unsecured creditors committee in smaller cases, but they are required to try to establish one, so the risk is always there. Note that there are some advantages to having a creditors committee, even for the debtor. Often, the unsecured creditors committee has leverage to push back against overreaching by secured lenders that a debtor, who may need to use cash collateral or require DIP funding, or debtor in possession funding, for instance, lacks. The absence of an unsecured creditors committee does, however, significantly reduce a debtor's costs, as debtors generally are required to pay for the professionals hired by the Unsecured Creditors Committee as an administrative expense of the estate. We now turn to the Consolidated Appropriations Act. The Act was enacted on December 27, 2020, in response to the COVID-19 pandemic. It is currently set to expire on December 27, 2022. The Act included many amendments to the Bankruptcy Code that are helpful to small businesses. First, it enabled debtors under Subchapter V, as well as Chapters 12 and 13, to obtain Paycheck Protection Plan loans. General Chapter 11 filers, however, were not included in this benefit. The Act also extends certain deadlines for debtors that lease commercial property, including the deadline to perform post-petition obligations and that to assume or reject leases, which we will discuss in greater detail. Finally, the Act modifies existing preference laws to encourage vendors and landlords to deal with small businesses that are in distress, so as not to prematurely force them into bankruptcy. Debtors are required to comply with their obligations under unexpired leases post-petition. If a debtor fails to do so, a landlord can move for relief from the automatic stay, and the debtor risks losing the property. The Bankruptcy Code provides that a debtor can apply for a 60-day extension after the bankruptcy petition is filed to comply with its obligations to perform under an unexpired lease of non-residential real property. Under the Consolidated Appropriations Act, this time period can be extended for an additional 60 days, for a total of 120 days, if the debtor is experiencing or has experienced a hardship due to COVID-19. This is a great help for many small businesses that need the additional time to become compliant and would otherwise risk losing valuable locations. Section 365 of the Bankruptcy Code deals with unexpired leases of real property, among other things. It previously, prior to the Consolidated Appropriations Act, provided generally that a debtor must decide whether to assume or reject a lease of non-residential real property within the first 120 days of filing its bankruptcy petition. The Act amends Section 365 D4A of the Bankruptcy Code for all debtors, not just Subchapter V debtors, to extend the deadline for a debtor-tenant to assume or reject a non-residential real property lease by an additional 90 days to a total of 210 days after the petition date. Since Section 365 D4B1 of the Bankruptcy Code already allows the court to extend the deadline to assume or reject a lease for cause by an additional 90 days, a debtor now can potentially have as many as 300 days to decide whether to assume or reject an unexpired commercial lease without the consent of the landlord. This can be critical because if the debtor wants to assume the lease, it is required to cure all defaults and arrears. Many debtors are now, as a result of the eviction and foreclosure moratoriums, in significant arrears on their lease. This additional time can provide additional time to speak with investors or obtain financing. It also provides leverage in negotiating new terms with landlords. Section 547 of the Bankruptcy Code deals with, among other things, the recovery of what are termed preferential payments. In general, if a debtor pays a vendor or a landlord within 90 days before it filed for bankruptcy for goods, services, rent, the bankruptcy trustee or debtor can avoid and recover that payment for the benefit of the estate. The benefit of the estate means that the recovered funds are meant to be distributed pro rata to general unsecured creditors. The theory is that when making that payment, the debtor preferred one creditor over another, perhaps because of dunning letters, refusal to continue to provide goods and services, or perhaps even a close relationship. Perhaps they were friends. Remember that one policy of bankruptcy is to put all similarly situated creditors on equal footing. This is a very complex area of law and very nuanced, so a detailed discussion of preference law is really beyond the scope of this presentation. There are defenses, but often I find it very difficult to explain to a vendor in particular that even though they provided goods and services that they can't take back, they have to give back the money they received for such goods and services. The Consolidated Appropriations Act aims to incentivize landlords and vendors to offer flexible payment terms to debtors by amending the preference provisions of Section 547 to provide that any covered payment of rental arrearages or covered supplier arrearages cannot be avoided as preferences. In order to qualify for this exemption, the debtor and the counterparty must have entered into the lease or contract before the petition date. The lease or the contract must have been amended on or after March 13th of 2020, and such amendment must have deferred or postponed payments due under the lease or the contract. It is important to note that there are some disadvantages to Subchapter V bankruptcy. First, increased scrutiny. Because there is no creditors committee appointed to oversee the process on behalf of all creditors, the Office of the United States Trustee is typically more aware and involved in the process. Notably, the debtor is required to produce and file with the court its most recent balance sheet, profit and loss statement, and cash flow statement, as well as its most recent federal tax returns, or to file a statement under penalty of perjury that none has been produced or filed. Typically, such documents are only made available to the Office of the United States Trustee and the Creditors Committee, but in Subchapter V, there's no Creditors Committee, so additional information is available to individual creditors, more so than is typical in a Chapter 11 case. Additionally, a Subchapter V trustee is appointed. The Office of the United States Trustee appoints a separate trustee, whom we will discuss in more detail shortly, to assist in overseeing the process. This creates one more party for a debtor to answer to, although their powers are limited. Finally, the expedited timeline. There is a much shorter timeline because there's a presumption that the plan must be filed within 90 days. This is much shorter than a typical case under Chapter 11, where a plan may not be filed for months or even years. Extensions are not as readily granted. The debtor must establish that there were factors beyond its control that required or prevented it from filing the plan. Because there is a presumption of no creditors committee in a Subchapter V bankruptcy, a Subchapter V trustee is appointed at the inception of the case to oversee the plan process. The Subchapter V trustee, however, has limited powers. This is a supervisory trustee, not an operating trustee, so the debtor will still remain in possession of and continue to run and operate its business as such. The role of a trustee in general is to account for all property received, examine proofs of claim and object to improper filings, to oppose the debtor's discharge if advisable, and to furnish information concerning the estate if requested by a party in interest, and then to make a final report and account of the administration of the estate. A Subchapter V trustee, however, has significantly limited involvement in the case. Its primary obligations are to facilitate the development of a consensual plan of reorganization and to make distributions under the plan in some cases. As in a general Chapter 11 bankruptcy case, a debtor can be removed as a debtor in possession for cause. This would be in the instance of fraud, dishonesty, incompetence, mismanagement. In the case of a Subchapter V bankruptcy, if the debtor is removed for cause, then the Subchapter V trustee takes on an expanded role. In this case, he or she is required to file monthly operating reports and operate the business, and they may enter into ordinary course transactions and obtain ordinary course unsecured credit or incur unsecured trade debts as administrative expenses. I hope that you found this presentation interesting and informative. If you have any questions, I would be happy to speak with you. You can reach me at 917-447-4321, or you can email me at adrienne@woodslawpc.com. I also invite you to visit my website for more articles on bankruptcy at www.woodslawpc.com. Thank you.